Thank you. Thank you both very much. Okay, the next case on the docket is Ross versus Tower Hill. Okay, you may proceed.
May it please the court, my name is Amanda Felton, the law firm of Weber, Crabb & Wien. We represent the appellants, David and Stacy Ross, in this case. Your Honors, the Rosses appeal portions of the trial court's final judgment, which is found on page 458 of the record, which was entered upon competing motions for summary judgment. Today I'm going to first address the trial court's erroneous denial of the Rosses' attorney's fees after the trial court entered final judgment on count 2 in favor of the Rosses.
Did the trial court actually enter final judgment in favor of the Rosses? If my recollection looking at that final judgment is the trial court said that the parties seemed to be in agreement as to how the repairs are going to be made, and then that was it. So how is that a final judgment in favor of your client?
Your Honor, the trial court definitely entered final judgment on the Ross's count 2 for declaratory relief. That's confirmed not over in the order granting the motions for summary judgment, which is found on page 437 of the record, where the court says plaintiff's motion for partial summary judgment is hereby granted as to count 2 for the claim for declaratory judgment. In the final judgment, it recognizes that the Rosses were granted final judgment as to count 2 of the plaintiff's complaint. On page 458 of the record, the court found the method of repair to be recommended by the neutral evaluator.
But isn't that because the trial court thought that they had come to an agreement and basically settled the case and said, here's the judgment? I mean, isn't that the reasoning of the trial court entering the judgments in the first instance?
Your Honor, the Rosses filed a count for declaratory relief. They're alleged on page 4 of the record in their complaint at paragraphs 25 and 26 that a bona fide dispute existed as to the method to repair the subsurface of the property. Tower Hill files an answer in this case denying paragraphs 25 and 26, denying those exact allegations of the complaint. They also attached to their answer an affirmative.
But my question is, didn't the trial court enter the summary judgments on the understanding from the parties that they had basically reached an agreement as to how to end the case and how to resolve it? You're saying that's not correct?
No, Your Honor. I mean, respectfully, the parties arrived at the motion for summary judgment hearing saying there was no issues of disputed material fact. This was not a little dispute. There was a substantial difference in the method that Tower Hill proposed to repair the subsurface of the Ross's property with...
You're entitled to attorney's fees if the insurance company wrongfully withholds benefits. Is that right?
Your Honor, for count 2, the Rosses are entitled to attorney's fees under statute 627-428 if they obtain a judgment in their favor against Tower Hill.
I thought the case law said in the context of sinkhole losses that the sinkhole provision applied. Let's just focus on the sinkhole provision.
Yes, Your Honor.
Wouldn't that say that you would have to somehow demonstrate that the carrier wrongfully withheld benefits to be entitled to fees?
No, Your Honor. Not in the context of the declaratory action that the Rosses filed.
So you can bypass all of the provisions in the sinkhole provision. If I understand what happened here, they report the loss. Tower Hill retains a geologist or engineer or somebody who goes out and does a report. Tower Hill furnishes that to your client and says, we'll pay you for the above-ground damages, we'll pay you for the underground damages when you enter into a contract. Nothing happens for a while. Apparently, there's some dispute over whether they knew or didn't know that you had retained your own expert. But in any event, they were prepared to go forward with what their expert had told them was necessary. And
Which respectfully, Your Honor, they now agree was wrong.
I understand, and it may have been wrong, but the question is, was it wrongful for them to rely on that? And my understanding of what the Supreme Court said in the Warfel case was that the presumption of correctness that attaches to that report appears to be aimed at shielding, among others, insurance companies from claims of improper claims denial. So my question is, now again, if they had gone out and retained the janitor to do the report, that'd be one thing, but they apparently retained a qualified person who may have gotten it wrong. I don't know if he got it wrong or not, but even if we assume he got it wrong, they comply with the statute that says you have to have an expert take a look at the property and determine if it's a sinkhole, and if it is, what method of repair is necessary. They did that, and the expert said, we recommend method X. You know, your expert said, no, we need X, but we also need Y. Didn't they have a right under the statute to rely on their expert until, at least until they became aware of this other opinion, and then they sought neutral evaluation, and then once, and I understand that the neutral evaluator kind of reached a middle ground. He said, you need more than what they said, but not quite as much as what your person said.
Respectfully, a few points. I'll address a few points. In Warfel, the Florida Supreme Court addresses, and you cited the language from that statute. They're talking about 627, 7073, and the subsections thereunder about this presumption of correctness. They clearly state in that opinion that that presumption of correctness does not apply to the litigation context. That presumption of correctness applies to the insurance companies during the process of evaluating the claim. Once we get to litigation, that presumption vanishes.
That gets back to Judge Warfinger's original question. Don't you have to show that there was a wrongful denial of benefits? And how can they do that when the statute says that the report from the evaluator is presumed to be correct?
Because, Your Honor, what the insurance policy in this case states and what the sinkhole statutes state is that Tower Hill is promised to do a repair that will stabilize the Ross's property. When they recommend a repair method that does not stabilize the property, and they now agree that their repair method that they initially recommended would not only not stabilize the property, but could lead to ground collapse and trigger soil collapse, then they did breach their obligation. But that actually goes to the Ross's claim for breach of contract, where there's the arguments about whether they breached that contract and what damages would be thereunder. But my first point is actually as the declaratory action in count 2, and there's nothing in section 627.428 that says anything other. It's very unambiguous. Upon the rendition of a judgment or decree by any courts of this state against an insurer and in favor of any named or omnibus insured, the appellate court and the trial court shall award fees. We're not talking about an issue where a case where a lawsuit is filed, the parties then agree to...
There's a lot of cases out there that says that 627.420, even 627.428, only applies when the insurer wrongfully withholds payment of the proceeds. I think you're misreading Warfel, because you say that it doesn't apply in the litigation context. You're right and you're wrong. I think that what Warfel said was that the presumption of correctness wasn't an evidentiary presumption, but it was a pretrial vanishing presumption, so that once, if the insurance company complies with it, they're allowed to rely on it. Now, if you can come forward then and have countervailing evidence, the presumption disappears. At that point, there's no presumption in favor of or against the insurance company. But I don't think that it's a fair reading of the sinkhole statute to say that you can bypass the process that the legislature created simply by filing a deck action against them.
Your Honor, Tower Hill has cited no case and no statute which prohibits the Rosses from filing a declaratory action to determine the coverage that is due under this contract. Warfel, and the court said, the presumption applies to the initial claim process and investigation that insurance companies are required to follow in accepting or denying claims. In that process, that statute was enacted to make sure the insurance companies don't just wholeheartedly deny these claims. They have to go through a certain process to do so. It governs the insurance company's behavior during the investigation process. It does not govern what coverage Tower Hill is obligated to give the Rosses. And if that were the case, that the Rosses were only due the coverage that Tower Hill's engineer told them to, then they would have been, then their coverage is literally limited to.
No. I think you're confusing a right to attorney's fees to a right of coverage. If, for example, the Tower Hill expert had come out and said, the damage to the house is not from sinkhole, it's from something else, soil shrinkage or something. It wasn't a sinkhole. And he's a qualified, he meets the criteria of the statute, whatever that is, you know. And so as a result of that, Tower Hill says, look, we don't dispute that your house was damaged, but it wasn't from a sinkhole. And so they offer you $0. You file suit against them, and you're able to prevail and prove that it was a sinkhole that caused the loss. At least up until the point that they get countervailing evidence, aren't they allowed under the statute to rely on their expert's opinion?
Tower Hill can rely on their expert's opinion in making that coverage decision. It's my reading of Warfel, and it's our position that that case deals with the claims process. And later on, the Rosses cannot come and file a bad faith claim against Tower Hill for not doing what they were supposed to do during the claims process.
What does the Supreme Court mean when it says, and I'm quoting, the presumption of correctness appears to be aimed at shielding insurance companies from claims of improper denial?
Improper denials. You did something wrong during the process of your investigation in accepting or denying the claim.
So what does that mean?
We're not claiming that they did something wrong.
You're claiming that their expert got it wrong and recommended less than appropriate repairs.
Right, because the policy requires that Tower Hill, they make the promise, we're going to fix your property, Ross, to the Rosses. We're going to do whatever it takes to stabilize the land. They now agree, everybody's in agreement, we all told the trial court we agree that what they initially planned was not going to stabilize the land. That was the arguments that were made going towards count 1 for breach of contract. Count 2, the Rosses are entitled to fees based on a judgment of the pleadings. Focusing on count 2 for the declaratory action, we said to the trial court, there's a dispute about the proper method of repair to do what Tower Hill promised to stabilize the land. They're telling us only compaction grouting is required. We disagree, there's a dispute. Tower Hill filed their answer and defenses. There is a dispute. They requested neutral valuation. Exhibit A to their answer says the issue's in dispute. What is the proper method of repair? The neutral evaluator says not only do the Tower Hill's expert said that compaction grouting was required, the Ross's expert, the basic engineering company, said they believe compaction and chemical. The neutral evaluator went a step further. It wasn't a middle ground, it was a step further. They said, we're going to actually have to pin the property under certain portions of the property, because once you start the grouting, the soil could collapse. The Rosses filed a partial motion for summary judgment on count 2 only, and the court entered judgment in their favor. And under 627-428, a judgment in the favor of the insured and against the insurance company, the Rosses are entitled to fees. The breach of contract issue, setting that aside for a moment, the trial court's denial of fees, even though they granted summary judgment in favor, or final judgment in favor of the Rosses, was erroneous. This issue, I think, is clear from an unambiguous statute and from a clear record.
It seems
Hill.
like what you're arguing is that an insurance company, an insurer, can follow the statute, get an engineer out there, the engineer says this is what needs to be done, X needs to be done to repair it, be willing to pay that, and the insured can have another engineer's report, keep it in their pocket that says something else needs to be done, and then turn around and sue the insurance company, and the insurance company didn't know about it, but then the insured would still be entitled to fees in that situation.
The homeowners are entitled to hire an attorney and obtain an engineering report and do so, and they have no statutory or contractual obligation to give Tower Hill a report prior to entering suit. Those arguments that are...
But then that doesn't, the presumption of correctness of the report that the insurer got doesn't vanish then. And that the report that they initially got is presumed correct, and if you didn't give them your report to show that it was incorrect, that report that they got is presumed to be correct, and they can't be a wrongful denial of benefits if they're relying on a presumptively correct report.
And the reading of Werfel, our position is that the engineer would not be liable for that decision, and Tower Hill would not be liable for bad faith claim afterwards. In this case, the basic report is given to Tower Hill post-suit. The suit's filed, they get the basic report. They don't immediately look at the basic report and say, we were wrong, it was the wrong type of repair, let's settle this. They file an answer, 11 affirmative defenses, and they wait until the conclusion of the neutral evaluation. At that point, there's conflicting evidence. If we're talking about the presumption standard, the neutral evaluator says in its...
Isn't that the whole purpose, though, of the sinkhole statute, that there's going to be reasonable differences of opinion amongst engineers? And so you've got the neutral evaluation process where you hopefully have qualified engineers making the call. Most policies have an appraisal provision in there. I mean, isn't the whole framework of the statute designed to keep people from running to court and suing over these things and trying to get the claims resolved the way the engineers say, as opposed to creating lawsuits that are driven primarily by fees?
Your Honor, respectfully, the statute was also enacted, as the Florida Supreme Court sets forth in Werfel, to make sure that insurance companies don't just wholeheartedly deny claims based on the engineer company that they now admit is correct, and it guarantees the homeowner that there's going to be a certain process that the insurance company is going to follow before they deny their claims. In this case, it's undisputed before the trial court that the insurance company's engineer was wrong. What they're insisting on is that the Rosses were required to enter into a contract with a third party, sign a contract saying we're going to pay you to do repairs that were insufficient and which they now agree were unsafe.
No, what their letter said, if I understood it, was we're not going to pay you for the subsurface repairs in the, whatever the amount they said. We can't pay you this until you've entered into a contract. It didn't say that you couldn't engage in the neutral evaluation process or the appraisal process, both of which would have allowed you in a non-judicial way to determine both the cost and the scope of the repairs. It just said, as required by statute, we can't pay you for subsurface repairs until you've entered into a contract.
Which is their argument is a condition of their payment obligation. The neutral evaluation process is not mandatory. It's
mandatory if someone asks for it.
If someone asks for it.
It's not binding, but it is mandatory.
It's not mandatory that the Rosses request it prior to filing suit and getting an attorney. If they would have requested the neutral evaluation process prior to filing the lawsuit, prior to having an attorney that would front the cost for the engineer's report, the neutral evaluator evaluates the documents that are given to them. They don't necessarily go out to the property and conduct additional soil borings or any additional testing. The Rosses would have nothing to say, no, we're pretty sure there's a sinkhole here and we require additional subsurface repairs other than what you've recommended, Tower Hill. But all these arguments really go to the fact that this is what could have been done or what the Rosses could have done or didn't do. In this case, Tower Hill, there was a dispute as to the method of repair. Tower Hill admits there was a dispute as to the method of repair. That is clear from the record. It's clear from their answer brief. And the trial court entered a judgment in this case in the favor of the Rosses. It said, as to the issue of how this property is to be repaired, judgment in favor of the Rosses. There's a judgment here that Tower Hill cannot deny, and now they want to absolve themselves from paying any of the attorney's fees that are mandatory under 627428. They cannot point to a case that goes through this same factual scenario. They hire an engineer who recommends subsurface repairs, which they now admit were inadequate and unsafe. A lawsuit's filed. They file denials in the claim. They go to the conclusion of the neutral evaluation process, and the trial court enters a judgment. This is very different than a lot of the cases that are coming out from the courts and that are being seen where...
Would the trial judge have entered these judgments if he didn't think that the case was being settled and that y'all had come to an agreement as to how to resolve it?
I don't know, Your Honor. What he would have done.
Because I got the impression from reading through all this that that's why the trial judge entered the judgments to end the case, and because he thought y'all had agreed and that there really wasn't a dispute anymore.
There wasn't a dispute. After the neutral evaluator came forward and said that the proposed method of repair from Tower Hill was inadequate, Tower Hill said, we agree. What we originally were requiring you to do and enter into a contract for these repairs was wrong. We're now going to give you, we admit we undervalued the repairs required to your home for $70,000. We now admit that. There was a dispute. The declaratory action in paragraphs 24 and 25 of the complaint say right there, a dispute exists as to the proper method of repair. Okay. Tower Hill admits that.
We'll look at it again. All right, you've gone well over your time.
Thank you, Your Honor.
May it please the Court, my name is Scott Samus. I represent the appellee Tower Hill. The Court has actually made just about every point that I was going to make in my oral argument. I would just clarify a couple of things. Judge Maltzis, to your point on count 2, there's a declaration. The declaration here was exactly matched what Tower Hill said in their answer. They said, we followed the statute, and these are in the affirmative defenses. We followed the statute, we did everything we're supposed to do. Now that we've been finally told that you disagree, we want to go into neutral evaluation. That's exactly what the court declared. This has been resolved by neutral evaluation. I think the argument that somehow when there's when a party files a declaratory relief action and the court actually declares something, that it's automatically a win for the party that filed the declaratory relief action is just wrong.
What did the court declare in this case? I thought the court declared that, well, basically they're in agreement and I'll just enter the judgments to end the case.
That's exactly right.
She says that's not right.
No, that's absolutely right. In fact, I have the wording. Final judgment says, as to count 2 of the plaintiff's complaint, the court found that the method of repair to the subsurface recommended and proposed by the neutral evaluator as contained in the neutral evaluation report was appropriate. Both parties seem to be in agreement, and thus there are no material facts in dispute and nothing for the jury to consider. Essentially said what Tower Hill said in their answer, we want to resolve this by neutral evaluation. The judge said it's been resolved by neutral evaluation. How that's a ruling in favor that triggers fees, I don't understand.
In the sinkhole context, let's assume that things go well in the sense that there's a loss reported, you send your engineer out, and what happens here? You know, he comes back and says, yes, it's a sinkhole, and you need to do X. They have a disagreement. They have their engineer that says, no, you don't need to do X, you need to do X plus. Is there any circumstance then, I agree that up to that point, you know, you're allowed to rely on the correctness of your engineer's report. Under your theory, is there any circumstance where they would be, other than maybe an offer of judgment or proposal of settlement, I guess, where they would be entitled to get fees if you continue to contest, you know, you say, no, we're only going to pay for X, and they say, no, you need to do X plus, and so you have a fight over that.
Sure.
Is there any and they win?
And they win, sure, absolutely, Your Honor. In fact,
So you think under that scenario that they would be entitled to fees under 627-428?
Absolutely, and in fact, if, that's what Warfel's about. Warfel's about that presumption disappearing at trial. So if we had said no, and they showed us their report, and it went to a lawsuit, and the jury believed their expert, then certainly they're entitled to fees.
At what point do you think that, from what point do you think they would be entitled to fees?
When the case is litigated and they get a judgment in their favor, the jury says, looks at both reports.
You know, for example, if we think about this case, let's assume that you hadn't resolved it at neutral evaluation. They gave you, at some point, they give you the report from BASIC that says you need to do more than what your expert said. And let's just assume hypothetically that your company had said, no, we're not buying that. And you litigated it, and ultimately they win.
Mm-hmm.
Do they get fees from the time they furnished you the report? Do they get fees from the time the jury buys, accepts it? Where is the point?
I think when they produce the report and create an issue, then they get fees from that point forward.
Okay.
Because that's when the presumption disappears.
I'm just trying to understand, because we seem to have a flood of sinkhole cases hitting us all of a sudden, and
Right.
I'm trying to understand what you think the lay of the land is and what other people do as well.
I think that's exactly it. And in fact, that's a good overall interpretation of what the legislature is trying to do in these cases. Because the thing about sinkholes is that it's not like a fire where you can send an adjuster out and, the kitchen burned and they can do Xactimate and figure out what to do. You don't want adjusters being geologists and engineers. This is a special circumstance. Not only that, it's the kind of thing where if you don't fix it, the damage continues. So it's like, you have a house that's on fire and you don't put the fire out and you keep making insurance claims. So they create this statutory schema that says, we are not going to just send an adjuster out to make this decision. We are going to make you hire an engineer. And then you have to follow the engineer's recommendation. So even if Tower Hill doesn't like what the engineer says, guess what? They have no choice. The engineer came back and said, guys, it's a sinkhole. This is what needs to happen. So what do? They say, we accept coverage. Here's $113,000 to do your above-ground stuff. And according to the statute, we are ready to write the check. In fact, they wrote 7 letters to them. We're ready to write the check for your subsurface. If you have any information, please let us know. Send us the contract. They hear absolutely nothing. I mean, they go...
How do you address, and again, this is a hypothetical circle. Let's say that you got $250,000 in coverage.
Mm-hmm.
But your engineer comes back and says you've got it's going to take $350,000 to fix the property. So you write him a letter that says, we agree it's a sinkhole, we're prepared to tender a $250,000 coverage as soon as you enter into a contract, and they write back and says, we can't enter into a $350,000 contract because we don't have $100,000. What happens?
The statute anticipates that.
Okay.
Because what happens is if they enter into a contract and then it's not enough, the engineer says it's not enough to fix the property, you have to either pay your limits or you have to.
But you can't pay them without entering into a contract. And they know going into it that contract policy limits aren't enough. My scenario was you're limited to $250,000, which
Right.
you're prepared to pay if they enter into a contract, and they say we can't enter into a contract because we all agree it's going to cost $350,000 to fix it and we don't have the difference.
I think as a practical matter, they typically pay limits in that, but I think the statute also has a provision for that, where if they enter into a contract and they start pumping, for example, here's the typical scenario, they start pumping grout into the ground, and $250,000 worth of grout is in the ground, and the engineer says, I can't sign off on this, it's going to take another $100,000 worth of grout, they have to continue paying with no credit for the money that's already been paid. So if they take that chance and let those repairs go forward instead of just writing the check for the policy limits and saying, see you later, that's one option they have. But if they don't do that, the statute says if it gets to the end and it's not enough to fix the sinkhole, you have to pay without the credit for the money you've already paid. So there is an anticipation of that situation as well. Now, of course, none of that happened here. I think what happened here is exactly what the statute anticipates. And really, this is a species of litigation that really needs to end. You know, if the court wrote an opinion that reversed here, it would just be a green light to say, let's hold back these reports, file suit, and then go try to get fees. Everything about, you know, Lorenzo and all the cases on confession of judgment are, they got to do something wrong. Everything about Wallard is about trying to prevent litigation. The signal in this case should be, if you've got the report, turn it over. That'll allow everybody to go to neutral evaluation. If neutral evaluation solves it, great. The statute and the policy have done exactly what they're designed to do, avoid litigation. If it goes to neutral evaluation and everybody disagrees and you still got to go litigate it, then that's a legitimate case to go litigate it. And if they win, they get fees, no question. So we ask the court to affirm.
Okay, thank you both very much.